Tier 1. And so I believe we go back to 306. Senator Frank Duggan.
Thank you very much, Mr. Speaker. And Mr. Speaker, I want to also thank our colleagues and the Majority Leader for allowing us to be able to rescind this legislation from the third reading. I do have an amendment. If you recall, the amendment to this particular legislation put in a caveat that any revenues above and beyond the projected revenues for this fiscal year, $50,000 would go directly to the Guam Veterans Affairs Office. Well, there's another mechanism in the budget that we all adopted back in August that allows the Chief Executive, should he be able to identify resources within the Executive branch budget, to use his transfer authority. And I want to ensure that if he feels, which I certainly hope he does, because he did transmit written communication in reference to the importance of this registry, I'm certainly hopeful that he will see fit to identify some of the necessary funds. So, Mr. Speaker, I'd like to request that on page 2 of Bill number 306, line 15, that the phrase, notwithstanding any other provision of law, be deleted. And that is the proposed amendment, just based on the reasoning that I have provided. And that, in essence, would allow the Chief Executive a little bit of flexibility. It would still require that if he's not able to use his transfer authority, that any projected revenues or any revenues above the projected level, then he would use $50,000 and have that authorization. But it also gives him that extra tool to use. So I ask our colleagues for consideration of that.
Any senator wish to be heard on the Uggan amendment to Bill 306? Is there any objection to the Uggan amendment to Bill 306? Hearing none.
Thank you very much, Mr. Speaker, and thank you, Senators. And a motion is appropriate to place it back in third reading. Thank you, Mr. Speaker.
Hearing no objection. The last bill in Tier 1. Is he ready with that? Are you ready with yours? I got word
just send it down to the third reading file?
I wish I could. But Senator, yes, thank you. As a father, I'm sure you understand. He has Christmas show this morning, and so he'll be in shortly. We're at number 18, Bill 402, Senator Dennis Rodriguez.
Good morning, Mr. Speaker. Thank you very much. Move to place Bill 402-32 on the third reading. Be allowed to briefly discuss the bill.
Hearing no objection.
Thank you, Mr. Speaker. Mr. Speaker, Bill 402 is an act to provide for the coverage of blood and blood derivatives by health insurance company or healthcare provider contracted to provide private sector, small or large group health plans. The intent really, Mr. Speaker, is to provide a mandate for this coverage. As we see now, there is existing mandate on the books that provide for this coverage for our GovGuam health plan, for our GovGuam employees, dependents, and retirees. And so what we'd like to do is also be able to provide this for those individuals who are in the private sector. We know that MIP, the public assistance programs, MIP and Medicaid also provide for this coverage. Mr. Speaker, you know, we have a Guam Comprehensive Hemophilia Care Program, which is under the Department of Public Health and Social Services, been operating since 1997, I believe. This program helps Guam's residents with hemophilia. You know, one of the things is helps them grow strong. helps them stay in school by knowing how to proactively manage their bleeding disorder. And over the years, what we have seen is that residents who are afflicted with this rare disorder, they're oftentimes obstructed by insurance plans, insurance plan restrictions. We know we got testimony during the public hearing and heard from some of the individuals who are experiencing this type of disorders that these people are able-bodied individuals that are able to work and be proactive citizens of our community. But we heard from at least one of the individuals is that he had to quit his job that he was working at because he was making money, he was bringing income, but then the private insurer doesn't cover the treatments that he needs. So then he had to quit his job and go into the public assistance roles to be able to get this coverage. And it was even, it got really bad for this family that because the wife also is an individual who is a breadwinner in the family that works. This individual had to separate from his family and move to the States because even the threshold here in terms of the MIP and Medicaid, he wasn't being able to qualify to be able to be covered by this, to be covered by the public assistance programs. And so what this does really, Madam Speaker, is that this policy direction we're about to set will help our residents with bleeding disorders get jobs and become tax-paying and productive citizens of our community. And so I know that there was concern by the industry that what we're trying to do here is attempt to roll back some of the waivers that we've recently seen that the federal government has waived for Guam in terms of Obamacare, but this is truly not the case. If you look at Section 2 of this bill, and it's clearly, what we're trying to do here is that the mandate that we're attempting to do here is really just pursuant to Section 2A of this Act, which is to help those individuals who need the treatment for coverage of blood and blood derivatives. And so I ask my colleagues to favorably consider this bill, and this bill will truly help those residents of our community who really need the assistance. Thank you very much, Madam Speaker.
You're welcome, Senator. On the motion, is there anyone who would like to speak? Senator Uggan, you're recognized.
Thank you, Madam Speaker. Just a quick question, Madam Speaker, if the sponsor of the legislation would mind yielding and respond to an inquiry in regards to the application of this provision. I think when you look at the effective date, I understand that having it effective immediately would always be the preference, but because the government of Guam's insurance program has already been adopted for the entire fiscal year, the question is, would the insurance companies more or less now have to incorporate this particular additional requirement into their benefits for the public employees and the retirees, and will that automatically translate into an adjustment or an increase in cost? Because I think that's what our people need to understand also.
Senator, do you yield to the question?
Thank you very much, Madam Speaker. Madam Speaker, as I stated in my opening statement, this is already a mandate that is provided for our public sector employees. So it's part of the plan already. So nothing would change.
Thank you very much to the sponsor of the legislation. Thank you very much, Madam Speaker, and for that clarification, just so that it's on the record again, even if it's twice over, that our people understand, the public employees and the retirees, that this is already inserted as part of the ongoing benefits provided to them in this fiscal year, and it should not translate into an adjustment or increase in cost. Thank you very much, Ms.
You're welcome. On the motions, anyone else? Senator Lim Tiaco, you're recognized.
Thank you, Madam Speaker. Madam Speaker, if I recall this public hearing, I wasn't in attendance, but I was watching on TV. There was overwhelming objection on the public testimony regarding this bill, and I just would like to see in the committee report if the author would yield just to have those concerns been addressed, because there were several testimonies that were in opposition to it for several reasons, and one that should be concerning not only to the plan members but also to the government of Guam was the increase in premiums associated with it. And so just so that I have the full picture, because I wasn't in attendance and I wasn't part of the actual committee report preparation, if the author would yield to just kind of how were those issues addressed, and what were the thoughts on on not only the Gov Guam side but also on the subscriber side regarding the higher premiums.
Senator, do you yield?
Thank you very much, Madam Speaker. Thank you to our colleague. Madam Speaker, the overwhelming opposition he talked about really came from one sector of the community, which is the insurance companies. And so, of course, it's kind of expected that we would have seen that type of opposition. However, Madam Speaker, the rise in rates really, is something that is always used in terms of when things like this come up, when we try to instill mandates and have certain protections for our community, the automatic response is that, well, this is going to drive up costs. We see now that with the government of Guam health insurance, you see for the past few years costs have been going down, benefits have been going up, and so, and as I mentioned, this is already part of the mandate that public sector employees must be covered in terms of blood and blood derivatives. And so, if you look at that, if you look at what is happening in the public side, the government health insurance where rates are going down, that might be an indication that, well, it might not be this way really in terms of rates going up so high for our private sector employees. And also, I think just for the record, I want to share with the body that that's why it's very important as we move into the next term that we take a look at some of the waivers that the federal government issued for Guam and the other territories in terms of some of the protections for our consumers. Rate review, the MLR. These are some of the stuff that were waived for the territories. But these are things that I believe we must, as a community, work with our insurance partners and see how we can somehow incorporate that, because with the rate review process, we know that in anything, any premiums that go above a certain percentage must go through this process. That was one of the beauties of the Health Reform Act. However, we know that that does not apply to Guam as a territory, but that's something that we really must seriously look at, and I'm committed to do so. And so if we have that in place as well, then we can still be able to protect our community in terms of premiums going up. But for this coverage, it's something that's already being covered now in our public, for our public employees, their dependents and retirees, also covered in our public health, public assistance programs.
Senator, was you able to respond to your question?
Yes, partially. And one of the, I know that with some of the changes in federal law, right? There's a percentage of utilization that needs to occur, and any premiums that are above and beyond that, right, have to be rebated to not only the government of Guam but also to the subscriber, if in effect. So from the cost perspective, I'm not sure that that's a valid argument for the insurance opposition, because they would have to pay it back anyway if the cost didn't meet that utilization rate. So,
point of information, Madam Speaker, if I may, he's right. The MLR, that the rebate is something that we have already embedded in our public, in our government of Guam health insurance plan. However, the waiver that was extended to Guam and the territories, does not. Guam now does not have to abide by those unless you have it in your agreement, just like we have in our government of Guam health insurance. And so, without being able to address that, and we're not addressing it here, but as I mentioned, that's something that we want to be able to address moving on to the next term. Those are the protections that will ensure that if it's not used, a certain percent is not used for actual health claims, then it goes back to the subscribers.
Okay. Senator, hopefully that will be able to help you.
yeah, thank you, Madam Speaker.
On the motion, Is there anyone else who would like to speak on Bill 402? There being none, would you like to close, Senator, or send it down? On the motion then to send 402 to third reading file without any objections, so ordered. Senator Maria Barnes, not here. Senator Uggan on 412.
Thank you very much, Madam Speaker. Madam Speaker, I'd like to move for the placement of Bill number 412, that's 32 COR, into third reading file for action by the body, please.
And you're going
And
to
it's a very
speak on it.
Thank you, Madam Speaker. It's a very direct amendment to an existing code, Madam Speaker, and it reads to require abortion providers to include gestational age in abortion reports. And there is already a requirement in terms of reporting some of these activities directly to the Department of Public Health, and it requires the age of the individual or the woman, as well as additional information describing the sequence of events. And this is just to include the gestational age as part of that particular information that's going to be gleaned. It would read gestational age as measured in weeks of the unborn child terminated by the abortion, and that would be the additional information that would be requested by this legislation should it be adopted and passed into law. I'd like to also close my comments, Madam Speaker, by not only asking our colleagues to consider supporting this legislation. It's informational in nature. It is not a pro or an anti legislation in regards to abortion, but it's requiring some additional information that other states are also gleaning from their community, and it would allow for better access in terms of knowing full well what the nature of some of these activities are taking place. So I ask our colleagues for their consideration, and I also thank the good Chair of Health for not only his co-sponsorship of this measure, but also for proceeding and reporting this legislation out. Thank you very much, Madam Speaker.
On the motion, is there anyone who would like to speak? There being none, then on the motion to send Bill 412-32 to the third reading file, no objections, so ordered. Mr. Vice Speaker? Mr. Vice Speaker?
Madam Speaker, you're recognized.
Thank you very much, Mr. Speaker. Mr. Speaker, I'd like to make a motion to place Bill 421-32 COR as amended by the Committee on Education, Public Library, and Women's Affairs. And it has to do with the administrative rules and regulations. Can I proceed?
You may proceed.
Thank you very much. Mr. Speaker, this bill is providing amendments to already an existing rules and regulations for the Guam Commission for Educator Certification. So when the bill was first created, we had to appoint the members, and then they had to put together rules and regulations surrounding, of course, the certification of educators. And that was done last year, and it had passed. However, there were several changes that have taken place, not only with the Guam Department of Education, but including the University of Guam, that now necessitates, of course, the Commission again adding now additional definition and changes and amendments to the existing rules and regs. So the amendments, some of the things that you would see are technical corrections that are essential to the existing law. And there's also several definitions that have evolved from recent developments. And if you look at the first page under even definitions itself, with the revision of GDOE's teacher performance evaluation, new terms were introduced that must be incorporated now with the GEC's rules and regulations. And just to give you an example, when you talk about receiving a satisfactory evaluation, what that now will indicate is that as of 2014, the Department of Education now said that satisfactory ratings will mean emerging, effective, or highly effective. Or the other would be unsatisfactory with a rating of ineffective. So this is a new definition now that has been in existence early on of this year. So what we're trying to do is to update that. Now, due again to an implementation of the Common Core throughout our schools, ETS, which is the Educational Testing Service, has replaced now Praxis 1 test with the Praxis Core Academic Skills for Educators test. So then that in itself again is part, as you see the underscore on A, B, AC, and AD, and how now that NCATE used to be the accreditation for teacher education, and the university had adopted it, but changes were made. So now NCATE has merged with TAC, which is the Teacher Education Accreditation Council, to form now another group called CAEP, which is the Council for Accreditation of Educator Preparation. And that went on effect, of course, on July 1, 2013, and NCATE should now cease by 2020. So that's the second reason again for these amendments. Excuse me. Then now the other is by adding the requirement for passing Praxis 2 content test for initial educator certificate holders, GCEC and the University of Guam will be aligned. Before they were not. The university was preparing, of course, the teachers, and then they do not take the praxis until they were done, and then later on they would take the praxis to get their certificate. And what we were finding is that some of the teachers were not able to pass the praxis, but by that time it was already too late because they've already graduated with a degree. The university now has worked with the commission, and now what they do is that even prior to them moving further on in their education to be educators, that they would have to take the praxis early on to make sure that they're able then to continue with the program. So now those two are aligned. So passing now this test proves that the teacher is highly qualified and guarantees that they have mastery of their subject area. So that before there were these two tests, there was just the basic entry level, which is Praxis 1, and then Praxis 2, which was in their content. And the most important, of course, was the content area. But of course, you must pass the basics, language, math, and comprehension. So moreover, with this test, that they have passed through this test, of course, professional or master educator certificate holders can also earn an endorsement in another subject area. So, and that's the gist of what is in this bill without having to go through all these. But what this is the most important to understand is that this already is an existing rules and regs, and what now the commission has done is upgraded it based, of course, on changes that were made in working with the University of Guam, and more importantly, to be able to incorporate now these new accreditation councils and commissions for our teachers to make sure that they're reflected as well in their standing rules and regulations. So I ask my colleagues to please consider giving this favorable consideration. It exists, like I said, in 5A GAR Education Chapter 8 Guam Commission for Educator Certification. Thank you very much, Mr. Speaker.
Thank you very much, Madam Speaker. Any senator wish to be heard on the on Bill 421? Any senator wish to be heard on Bill 421? Hearing none, Madam Speaker, do you wish to move it to third reading? I'll skip over my bill for right now, and Senator Limtiaco and Senator Respicio on 425. Which one of you?
Yeah, he's the main sponsor.
Okay, Senator Limtiaco. Thank you for allowing us to put your other bill on hold until Senator Nicholas comes back. So.
Well, if the body chooses to put forth 13 again, we can. No, I'm just kidding. We can. Thank you, Mr. Chair. Let's see. Bill 425. I'd like to make a motion to move it to the third reading file. Madam Chair.
Yes.
And I'd like the opportunity to speak on the bill.
You may proceed.
Okay. Thank you, Madam Speaker. Madam Speaker, throughout the 32nd Guam Legislature, this body has done a very good job of moving the Guam Apprentice Program forward. And Bill 425 is kind of the last piece of the puzzle to allow Guam to establish the state apprentice program on Guam so that we can manage the apprentice programs locally. What has happened in the past is that although we've been allowed to establish these apprentice programs, we had to go off-island to Hawaii as well as to San Francisco in order to get the programs and the companies approved to participate in these apprentice programs. And this, Madam Speaker, is a very big step for Guam and the Department of Labor, as well as to the economy as a whole for Guam, because it really does provide a means to develop our workforce. In the 32nd Guam Legislature as well, this body had passed an increase in the minimum wage, and although that increase was somewhat arbitrary in the sense that there weren't any value-added skills that warranted that pay increase, the apprentice program is designed to specifically prepare those unskilled laborers with the skill sets they need to not only earn more wages, but also to put them on a step to potentially even rise further past journeyman status into master status for whatever occupation they choose. And there are several companies throughout our island that currently participate in the apprentice program, and they are developing our workforce. And what it does for our island and for our government as well is that it increases the standard of living for these apprentices. It increases by increasing their wages, it also increases their tax contributions to our government, as well as their purchasing power. So it's a very excellent tool in order to not only progress our workforce, but also the standard of living, as well as to the revenues associated with the government in the form of payroll taxes, and of course their spending power and how they choose to push that money into the economy, purchase more goods, and of course those businesses and the government once again benefits from this. So what Bill 425 attempts to do, or actually will do, is provide the establishment of the Apprenticeship Act of Guam. And it allows for the formation of the Guam State Apprentice Council. It establishes the powers and duties of the director, the territorial federal cooperation, to name a few. But the gist of it is basically to allow us to manage our own state apprentice program. Several amendments came from the public hearing. Most notably was I believe it was Article 2. What the bill in its original form attempted to do was to encompass all of the facets of the equal opportunity clauses in the FAR, and that's the the CFR. And what we did instead was we removed all the specific language that this bill contained, because it was specifically citing the CFR almost verbatim. And so what came of the public hearing was we replaced that entire section and basically referred to the CFR so that it was all encompassing. And so, in addition, Department of Labor had a couple, as well as the Guam Contractors Association, had a couple of minor amendments to make sure that there was a differentiation between sponsor of the apprentice program as well as an affiliate, which the Guam Contractors Association is. They don't specifically employ those apprentices, but they participate in the development of that apprentice through the programs from the company sponsor. I do have one amendment, Madam Speaker, that was also part of the public hearing, and that was the fact that this was, in its original form, was sent to the administrator of the Office of Apprenticeship, U.S. Department of Labor, and it was approved in its present form. The changes that we have made don't take away from the germaneness of the bill itself, but it does significantly decrease the content of the bill, because we removed all of the specific language in the CFR and just referred to the CFR. So there is one amendment on page 6, lines 15 through 17, and that's in reference to any future amendment to the law will become effective upon the approval of the Administrator, Office of Apprenticeship, U.S. Department of Labor. And so I'd like to make a motion to strike out that language, starting from any future amendment and ending at U.S. Department of Labor. And those amendments appear on page 6, lines 15 through 17.
So but the act shall become effective upon enactment will remain.
That's correct.
So only the sentence after that on line 15, starting with any future, all the way to line 17 with labor.
Correct.
Any discussion? No objection? So ordered.
And so basically, Madam Speaker, if there were changes that would need to be made, and of course, once again, this was already approved by this same entity, the Administrator, Office of Apprenticeship, U.S. Department of Labor, of course it would have to come before this body, and then any subsequent changes would be made. Madam Speaker, I encourage our colleagues to participate in the debate on the bill. I ask for their support. It's a very good step in the right direction of putting the management of this program within our own borders, and it allow Department of Labor to promote the program and become much more efficient at getting participation from more of our local businesses, as well as really pushing for the development of our workforce throughout the island. Thank you, Madam Speaker.
You're welcome. On the motion, is there anyone who would like to speak? Senator Yamashita, you're recognized.
Thank you very much, Madam Speaker, for allowing me to speak on Bill number 425-32. I stand in full support of this act. I believe that workforce development is so crucial to the quality of life for all of our people, for all of our families. And I listened with great interest during the public hearing in what was stated, and I applaud the authors for moving forward and representing this that would help strengthen workforce development. I also want to acknowledge that the progress that has been made out of Department of Labor is to be upheld. They obviously through Region 9 have been acknowledged about the good work, and so we can now speak for ourselves, and I think that's a huge thing to celebrate. Madam Speaker, during the public hearing, I again, as always, raised the notion of people with disabilities, and that a part of our workforce development must always include those of us who look different, sound different, sometimes smell different, definitely work differently. And while we do have laws in the books that say that same thing, what I would like to do is to proffer an amendment to ensure that as we move forward to workforce development, that previous laws are always remembered. And so I have an amendment that I've passed around. I hope that everybody has received it. And it would be for page 2 of the bill, and it would be right after...
At the end of line 20.
Beginning on line 21. Thank you.
Yes.
That's correct. And so the amendment would read, this act recognizes that all citizens of Guam, regardless of race, color, religion, national origin, or gender, are a potential aspect of a reliable workforce. Moreover, an individual's physical and/or behavioral health challenge shall not prevent him or her from participating in programs authorized through this chapter, as every attempt shall be made by the Guam Department of Labor ensuring that apprenticeship programs are supportive of 17 GCA subsection 41210 relative to the employment of individuals with severe disabilities. Madam Speaker, this doesn't say that if you have a disability that you're going to automatically be accepted, approved, and supported. It doesn't say that at all. What it does say is that the opportunities to be considered are there. Most certainly, I wouldn't want certain people with disabilities to be given the opportunity to work on trucks, to drive trucks, when you clearly know that they cannot. There's different skill sets that would be expected, but what I am saying is that the 2% law really needs to be upheld. We have a 2% law on this island, Madam Speaker, that everyone seems to be ignoring, except maybe the Guam Legislature. It's really easy to ignore us. Until the police are called on us. And when the police are called on us, then we're acknowledged. But what this will do is it will say to all of the apprenticeship programs, is there a way, or how do we ensure that notices go out to DISIT, to Department of Labor, to Guam DOE about are our kids as juniors or seniors potentially capable of doing this work? And how can we bring them in to do some job shadowing, some job coaching, and then possibly actually earn a paycheck? And so this doesn't say that you have to accept our people, but it does say that you recognize that we are capable, we're part of a workforce, and that we should be included in these notices, and that accommodations shall be made, and that's a part of other laws that rule our country that make this a great nation, in saying that everybody is capable, and if given a chance, they actually can succeed. And so I ask for consideration by our colleagues in this, and it really simply supports previous legislation that was passed by this body.
On the amendment, is everyone Senator Lim Tiako, you recognize?
Madam Speaker, if I could just call for a quick recess to discuss with the author of the amendment. I want to understand 17 GCA 4210 as it's referenced in the amendment.
Okay, brief recess then. The legislature is back in session. Senator Lim Tiako on the amendment by Senator Yamashita.
Thank you, Madam Speaker. Madam Speaker, we thank you for the opportunity to recess and discuss with the author. And from what the discussion came about was that the amendment is in recognition and an attempt to recognize and do whatever we can to accommodate those with severe disabilities as part of this program. And I think that everybody in the body is in recognition of that and is supportive of it, in the sense that we want to do everything that we can to accommodate what this amendment chooses to do or attempts to do with those with severe disabilities. And I'm in support of the amendment. Thank you, Madam Speaker.
Thank you very much, Senator. So on the motion, unless Senator, you want to close on it? So on the amendment, not hearing any objections, so ordered. Thank you. Is there anyone else who would like to speak on the motion? There being none, would you like to close?
Thank you, Madam Speaker. Madam Speaker, just want to thank all my colleagues for their support for this bill. I really do see this program as being the impetus to really achieve what this body attempted to achieve by increasing the minimum wage. I really do see this program as allowing those that participate in it to really excel, not only from a job experience standpoint and a skill development, but also from a standard of living perspective. The amount of percentage increase in salaries that have come from this apprentice program are significantly greater than any minimum wage law we can pass, because it allows these employees to increase their salaries sometimes two to threefold. And that is much more progress than we're ever going to be able to do with the minimum wage law. Thank you, Madam Speaker, and I look forward to the favorable support from my colleagues.
You're welcome. So on the motion to send Bill 425-32 to the third reading file, hearing no objections, so ordered. Mr. Vice Speaker, on Bill 423.
Thank you very much, Madam Speaker. Madam Speaker, I'd like to move Bill 423-32 to the third reading file, and I ask a short opportunity to speak.
You may proceed.
Madam Speaker, I suppose one can say history repeats itself, or everything comes back around. About 20 years ago, while I was on the bench, and the current Attorney General-elect was the Attorney General of Guam. She terminated the employment of one of her attorneys. That issue was brought to the Civil Service Commission and was brought to the court. There is a provision in the Organic Act that says all GovGuam employees shall be classified employees unless it is some kind of impossible to have them as a classified employee. So what the intent of the Organic Act and the Congress was to have a merit system in the government of Guam. As impracticable. Yes. That's the word. I thought that under the Code of Professional Responsibility, that when an attorney is told his services are no longer needed, an attorney is supposed to ethically just bow out and remove himself from the case. I thought that was the same thing with the Attorney General's office, and I ruled in favor of the Attorney General's office. It went up to the Ninth Circuit, and by the time it came back down, the judgment for the attorney was in excess of $500,000. It was a very expensive lesson to learn that all employees of the government of Guam are mandated by the Organic Act to be classified employees. including attorneys in the Attorney General's office. 8 years ago, the public auditor came to this legislature and asked that she be given the authority to have her entire staff of the Office of Public Auditor unclassified. I tried to explain to her at that time that the Organic Act required that all government employees be classified, and I thought that it would not serve the people of Guam well that if the public auditor was to leave, like a governor is removed fails re-election, or one of us fails re-election, we can take our entire staff with us. Our entire staff leaves with us, but at least there are other senators and there's other people in place that have the historical knowledge of how departments operate, how different things operate. But if the entire office of the public auditor was to be unclassified, that it would be dangerous, the same way it would be to have all the attorneys unclassified, to have them leave whenever a new attorney general was elected. So I suggested to her at that time that if she wanted to have at least one person unclassified directly under her as a deputy, that there was a provision in law, and that's Section 4102, which had, at that, until today, 17 different exceptions of who are classified and who are unclassified. And it has as elected official, unclassified service shall include 1, elected officials, 2, judges, 3, and it goes on, and it goes down to 17. And Bill 432, 423, I'm sorry, I'm dyslexic. Bill 423 has a 2-sentence, 2-line amendment adding a number 18, not more than 1 special assistant each to the Attorney General of Guam and the public auditor. When the Attorney General-elect was successful in her election, she came and saw me, and she asked if it would be possible, without violating the House decision and without violating the Constitution, the Organic Act, if we would consider an amendment to the law to allow the Attorney General to have 1 unclassified person directly under her to manage the office and be her eyes and ears and in the office and move things, and would leave with her when she leaves. I thought that was reasonable. And so, though she may have wanted more employees to be unclassified in her office than the 1 immediate deputy, I decided that for parity, that I would also include the public auditor. So this bill provides for a number 18 in the exception of list of unclassified positions, and has that 1 special assistant for the Attorney General and 1 special assistant for the public auditor. And that would then at least provide for 1 person that would be in the unclassified service, that both of them, both being she, so I can say she, that she can depend on to operate the office, to be there to handle things, and she wouldn't have to worry about, they would be at her appointment, and so she could remove them without cause for whatever reason. And I thought that would be fair for both of the offices, just like all of us have special assistants and the governors have, and the directors have deputies. we would allow this for both of these two new offices. And so it's a very simple amendment. It was asked for by the general elect. I decided to also put one in for the public auditor so that she would at least have one that she's been asking for a couple of years. And it may not be the 10 that she wants, but I'm at least having one so that she can operate the office with a little more, at least they believe, more efficiently by having a unclassified deputy. And so I asked my colleagues to please consider both of the offices and their special assistant. And we all know how important our first assistants or our executive assistants are in our offices for the operation, and how we need to be able to remove them at will if for some reason they do not comply with or follow through on our instructions. And so I asked for support in Bill 423. It's quite simple, but I wanted to give the history of why we have 18 exceptions, because the Organic Act requires a merit system in the government of Guam in a classified service. So thank you very much, and I hope for support from my colleagues on this one. Thank you.
You're welcome, Mr. Vice Speaker. On the motion on Bill 423, Senator Yamashita, you're recognized.
Thank you, Madam Speaker, for allowing me the opportunity to speak on Bill number 423-32. Madam Speaker, I stand in full support of this. I believe, again, it's a human capital issue for a manager, a person of authority to be able to choose their team, and it just makes a difference. And to be able to hold them responsible and to decide if they're there or they're not there. I'm also speaking because yesterday I had started to offer amendments on another measure that was relative to the public auditors and was advised that was the wrong bill. And today I'm standing to explain that I will not be proffering those amendments to this bill. And I will not be because after further discussion with a couple of senators and a couple of staffers and my minority legal counsel, is just putting it all together, that we do have a Hay Plan study that is not being implemented. We're going into a year. That the positions that I was going to stand for needed to be reclassified during that process. And why they were not, I can't represent that right now because I don't know why. But they should have been and they weren't. We had a study that was done by Leading Edge to say what the compensation should be, but what I was also advised was that there wasn't a public hearing held with that study. And as we certainly appreciate the need for opportunity, public opportunity to be had on our measures, I absolutely agreed with that. So as I don't want to unravel, whether it's with the auditors, whether it's behavioral wellness and hazardous pay, whether it's with concerns, GDOE, that's now being addressed through civil service, I agree with Vice Speaker in that the unraveling of the Hay Plan, the pay structure, is something that we really don't want to do at this point. We want to see it proceed as a whole, take a step back, and then decide how, between the executive branch, the legislative branch, and the judicial branch, how we need to remedy the different aspects of it. And so I trust that this issue isn't going to go away in the 33rd Guam Legislature, and I do trust that the honorable senators in this hall at that time will address and continue to address the human capital issues that are definitely couched in the pay structure of our people. So for the record, I just wanted to tell the people why I'm not proffering the three amendments that I started to speak to yesterday. Thank you, Madam Speaker.
You're welcome. On the motion, Senator Respicio, you recognize.
Thank you very much, Madam Speaker. Madam Speaker, I just want to quickly rise to express my support for Bill 423 and to recognize the sponsor of this bill, whose position has evolved consistent in the same way as the public auditor's position has evolved as well over the years. As he pointed out, the mover of this, sponsor of this bill, as the Vice Speaker pointed out, Madam Speaker, originally the public auditor wanted to have full hiring and firing authority of her staff. And we know that for several terms now, There was even a problem with the manner in which she hired a few of her staff and how the merit system was bypassed and how those salaries were not, the salaries that she set were not set by Civil Service Commission. So the Department of Administration, even I believe the Attorney General made a ruling that what she did, or the courts rather made a ruling that what she did had to be consistent with the laws, and that she does not have the authority on her own to hire and fire people who are in the merit system and who are in the classified service. This legislature has consistently taken the position that the employees of the public auditor have to have merit protection so that they're not at-will employees and they don't come and go as the person elected at office comes and goes. In the same manner as the staff of the attorneys at the Attorney General's office, they have to be there to stay regardless of who the political or the nonpartisan person that gets elected to those respective positions. I support the bill, and I also want to recognize the public auditor publicly, colleagues, for agreeing to some kinds of compromises. As you know, in the last session, we provided her the provision that she can hire employees, but that those employees will be subject to an audit within 6 months, and the audit is to be conducted by the Civil Service Commission. So there's some semblance of checks and balances in terms of those employees that are hired, the salaries that they are given, and it's all consistent with law. And what this bill does, it gives additional flexibility not only to the public auditor but to the Attorney General, so they would have this one special assistant that like the sponsor said, would be the eyes and ears, and that would help carry out, he'd help the public auditor and the Attorney General carry out their duties more effectively. But more importantly, I wanted to say that this legislature has always stood in strong support for these two offices to make them as independent as possible, to shield them and insulate them from the day-to-day politics, and to really give them the dignity that those two offices deserve, so they can provide for the kind of stability that this government needs and our people deserve. So thank you, Madam Speaker, for giving me an opportunity to rise in full support of this bill.
You're welcome, Senator. Anyone else who would like to speak on the motion? Okay. There being none, Mr. Vice Speaker, would you like to close?
I just would like to add Senator Yamashita is a co-sponsor of this legislation, and then ask that if there's no objection, and then to move it to voting file.
On the motion to add Senator Yamashita as the second co-sponsor, hearing objection, so ordered. And on the motion to place 423 in the third reading file without any objection, so ordered. (426), Senator Tamada, you're recognized.
Thank you, Madam Speaker. I move that Bill 426-32 COR, annotated as substituted by the Committee on Aviation, Ground Transportation, Regulatory Concerns, and Future Generations, be accepted and moved and placed in the third reading file, and I'd like to speak on it.
This has been it's the bill that was reported out by the committee as substituted by?
Correct, yes.
Okay, so then for placement into third reading file, and you'd like to speak?
Yes, ma'am.
You may proceed.
Madam Speaker, Bill 426 really is more of an administrative housekeeping matter. And what happened was back in 2012.
What is it?
No, I was hearing a...
It's not affecting the mic or anything?
No,
Okay.
I think it's just the air conditioner.
Okay.
Back in 2012, the March 26th of 2012, the federal grantor that funds the Motor Carrier Safety Assistance Program conducted an audit of the program itself, and during that audit found that the that 49 CFR Part 180 was not properly adopted, was not formally adopted. I guess there was the understanding that it was on the part of Revenue and Tax, but the audit showed that it wasn't. So what we're doing in Bill 426 is to basically rectify that finding, so that then the grant that the program receives is not jeopardized, and they can continue on with their mission of providing motor carrier safety assistance inspections. And with respect to what we're adopting, 49 CFR Part 180 really focuses on the proper packaging and marketing of hazardous materials to ensure the safe transportation of these hazardous materials. And so in reality, the Department of Revenue and Taxation Motor Vehicle Division has actually been enforcing these regulations for a period of time. It's just that now we need to formally adopt it, and to do so by the end of this year in order to come into compliance with the program. So I ask my colleagues to support this bill.
On the motion, is there anyone who would like to speak on the motion on Bill 426? There being none, would you like to close, or we'll just send it? Okay, so on the motion to send 426-32 to the third reading file, hearing no objections, so ordered. Bill number 326. Mr. Vice Speaker, did you?
Madam Speaker, on Bill 326, I'd like to move that that bill be moved back to committee. I did have discussions with the stakeholders in this particular bill, and everyone was in agreement that at this time we should send back that bill to committee.
Okay, thank you. So on the motion then to send 326 back to the committee, hearing no objections, so ordered. Bill Senator San Nicolas, Bill was there anything? Senator Munya Barnes on Bill 405.
Sidus Masi, Madam Speaker, and Manana Sidus. If I may, Madam Speaker, I'd like to move Bill 405-32 COR to the third reading.
As introduced? It's not,
as introduced.
Okay.
As introduced. Por favor. And if I can speak briefly on it, I'd appreciate it. Sidus Masi. Madam Speaker, and to my colleagues, Bill 405-32 COR is an act to amend Section 4108C2 of Chapter 4, Title 4 of the Guam Code annotated, and this is relative to sick leave. And after much concerns, Madam Speaker, from our constituents who have come in to speak to us on this, oftentimes employees find the need to be absent from work or from duty to provide for the health care of an immediate family member. And at this time, Madam Speaker, statute says that in order for them to do that, they must exhaust all their annual leave before utilizing sick leave. And Madam Speaker, this bill and its intention is to just afford the opportunity for employees within the government that if they had to take care of a loved one, take care of someone who was really sick, that they be given the opportunity to do so by utilizing their sick leave. It is a benefit to them. We know that as a part of a benefit to the employee, we are given both annual leave and sick leave. And you and I know, Speaker, as a mother and as a grandmother, it's not easy sometimes when you have a loved one who's really, really ill and having to take care of them when there's nobody else to. The opportunity to utilize sick leave can be very, very vital and important. And the provision for this, Madam Speaker, is to amend the section in Chapter 4 to allow the employee who wants to take care of a loved one to be able to utilize their sick leave. So I'm asking that my colleagues please think about this issue and afford our people who are working hard the opportunity to be able to use the leave that has been provided to them to take care of a loved one. We know that the government receives both annual leave and sick leave, and annual leave is capped. And some folks don't even receive or only receive a certain hour, a max on the hour that they're received for annual leave. And being afforded the opportunity to use sick leave, Madam Speaker, will go a very long way. We did receive testimony on this from a constituent who worked in the education department, who was saying that she was the primary caretaker for her grandmother, and a lot of times it was difficult for her to get away. And utilizing the sick leave that she has today would really help out in making ends meet for her. And I know that this has been shared with a lot of constituents who have come my way asking us to at least revisit that and give them the opportunity to use their sick leave, their benefits, in order to take care of a loved one. So, Madam Speaker, it's really simple, it's really short, and I hope that my colleagues will at least give me fair consideration. I'd like to thank my co-sponsor, Senator Ada, for this. I know he too received some calls regarding this issue and had some people talk to him. So we said that this may be something that we can look at, and it's on the floor for our colleagues to visit, and I'm hoping that they can give me their favorable consideration. And I want to thank you for giving me the time to speak. Sana Masi.
Welcome, Senator. On the motion, Mr. Vice Speaker.
Thank you very much, Madam Speaker. Madam Speaker, I just wanted to point out that in the committee report, at the very end, we received a letter from the Department of Administration to the Director in support of this piece of legislation. I was a little hesitant about the bill initially because I wanted to find out how Department of Administration, who would be administering this, and the HR people on how this would affect leave, what their position was going to be. And I was able to report the bill out after receiving the letter from the Director of Administration in support of the legislation.
Thank you very much for that information. On the motion, is there anybody else who would like an opportunity? Senator Limtiaco, you're recognized.
Thank you, Madam Speaker. Madam Speaker, I certainly understand what we're trying to do with this bill, however, I do have some reservations. The whole intent of sick leave is for the individual. It's an employee benefit. And the way that the initial law or existing law is structured is such that in the event that an employee has to care to their family members or anybody for that matter, that they use the leave that is afforded to them through the annual leave. The employees have the choice on how to use that. They can use it for vacation, they can use it for such things as this, or any other event for that matter. It's at their own choice to do it. What the bill is attempting to do is to basically allow for the use of sick leave for something other than its original intent, is when the employee is sick, themselves are sick, and they cannot report to work. I understand what they're attempting to do here, but it really the original law is actually very well written, and it accomplishes what it needs to accomplish, especially for the taxpayers that are funding the government. My issue, though, it really is in the disparity between the private sector and the public sector, and the fact that we already have these issues with the retirement plan and Social Security and the inability for workers in the private sector to flow through the public sector and back in and out. It basically divides our workforce. This further divides it because in the public sector, this type of thing wouldn't otherwise be allowed. It's sick leave for the employee, okay, and annual leave. And sometimes a lot of employers are just not even differentiating between it at all. They're just saying you have X amount of leave, you use it however you want, okay, rather than differentiating it. But my main concern is that we continue to have legislation that further divides workforces within our island, and it doesn't prevent the flow of very qualified applicants that would otherwise consider public sector employment or private sector employment to flow in and out of that. And that's a real problem that we continuously, rather than mending that and bridging those gaps, we further put more gaps into our workforce and further divide the workforce. And you know, I know, Vice Speaker, that you probably share the same concerns. We talked about the retirement fund in previous bills, and although these are two totally different issues, they're one and the same. We're polarizing the workforce throughout our island, and we're continuing to add in further obstacles that are going to prevent that workforce from coming in and out of the public and private sector, and we cannot continue to do that. It's not good for the private sector, it's not good for the public sector, because we both miss out on opportunities for those very well qualified individuals to flow in and out of it. And this bill attempts to do the same thing. I get what they're trying to do here, and maybe the better way would just be to remove the classification altogether and just afford the employees X amount of leave, and that's it. And they can choose to use it however they want to, as opposed to differentiating between sick leave and annual leave. That might be the better way to go, but once again, my main concern is that we continue to put obstacles between the private sector and the public sector workforce that prevents those workforces from coming in and out, and it doesn't do our island any good to separate those workforces. They should flow in and out so that both sectors can compete, and this is also in regards to wages. We talk about the private sector wages, the Competitive Wage Act that was recently made into law, but if we work towards, instead of putting obstacles and differentiating between the two workforces, and work to make them one and the same, so that we can have qualified individuals move in and out of either employment, it's going to raise the bar for the entire island, in the sense that both sectors are going to be able to attract those qualified applicants. Thank you, Mr. Speaker.
Thank you very much, Senator. Madam Speaker, did I understand that you wish to speak?
Yes, thank you very much, Mr. Speaker, for the opportunity to provide some comments as well on Bill 405. I actually support this bill for various reasons. And, well, first of all, just to kind of touch on some of the points that were shared by the previous speaker, and that that I support as well, and it's something to consider maybe somewhere down the line as we try to align some of the policies within the government that could also be that's reflected in the private sector, to have just one leave, not necessarily designating it as annual leave and designating it as sick leave. And that sounds something that could be worked on probably in the future. The other is that this is actually being practiced right now with the Department of Education, because as you know, teachers do not accrue annual leave, so they only accrue sick leave, and then they have what we call personal leave to be able to use for other matters other than being sick, because they don't have that designation of the annual leave. And those sick leave time that's provided for our teachers, that they use it as well to be able to be at home or to take their children, to the doctors or when they are sick. The one thing that when you read the bill, if you go into page 2, and this is how I think it would really cut any type of abuse whatsoever, in the use of their leave, because it actually speaks to the employee's immediate family members. What we're seeing right now with the leave sharing is that, and there are abuses to the leave sharing that is not necessarily immediate family members, it's anyone basically in the government, and there's no certification sometimes to verify this, and individuals can be out for months, even years actually, I've heard, because there is that leave sharing, that one person, then another person, then a third person, and it continues forever, because there are always individuals, with big hearts who want to help, not knowing, of course, maybe the situation. But the one thing that had convinced me, of course, not just some of the things that I spoke of earlier, but the fact that it's the immediate family member, a spouse, a child who is sick. I mean, for me, who wants to say that I'm going to use my sick leave because I have an immediate family member who's been injured or seriously ill, and this is an urgent condition, and A describes what some of those serious illnesses and injury are, and then there's that, again, prevention of abuse, because it has to be certified. Currently, when you use 3 days or more of sick leave, you need to get a certification from your physician, from a doctor, and then in this case, there it is, certified also by an attending physician. Also, when there is any requirement for hospitalization, institutionalization, or extended, home care. And then, of course, the definition of immediate family members, the spouse, or as you know, common law, as we call them, are life partners, parents-in-law, grandparents, brothers, sisters, children, grandchildren, and so on. So I, as much as I understand, the previous speakers' concern, I really think that we have enough means here to be able to prevent any type of abuse. Secondly, our people, and that's the one thing I love about our people here, is that, we're so caring. We want to always take care of family members. I realize that there's some things are starting to change, but I'm hoping that with this, maybe we would actually see where there will be family members who will be able to care for some of our elderly, because it's so unfortunate that now we're having to actually place them in homes because we're unable to take care of them. And, I just think that, it's a sad thing when that starts to happen in a community here that's so family-oriented, and I think if this would actually help to assist other family members who no one else can, that the best care will come from that family member. And I just think that the benefits are going to be far greater. That's immeasurable rather than, in dollars and cents. So ultimately, I think the long run, we would see benefits from this. So I thank, of course, the authors for the introduction of this and being very sensitive to the needs of, our people. So thank you very much, Mr. Speaker.
Thank you very much, Madam Speaker. Any other senator wish to be heard on the bill? Senator Yamashita.
Thank you very much, Mr. Speaker, for allowing me the opportunity to speak in support of Bill number 405-32. Mr. Speaker, those who have worked with me professionally know that I repeatedly say that work, particularly as a teacher, or even currently, it's not an employment opportunity. We're not there to make sure that that all of your needs are met, but it's an opportunity for you to work to help a mission be realized and to help progress or success of whatever organization we're doing or we're a part of. But in this particular regard, though, when I was first approached about it, I really thought about it. And I thought more and more about it, particularly when I spent a lot more time speaking to children of older parents whom are really torn because they need to work. They need to work, but they've got an older family. And they say to me, what am I supposed to do? Because they need to pay their bills. They're still taking care of their growing children, but they have their mom or dad at home. And they don't want to put them in a home. And they just don't know what to do. And that is a challenge that will be facing, that will grow in need for this body to talk about. The need, yes, to maintain and grow school facilities. It really now needs to be balanced with the need for living assisted facilities on our island. Our family sizes are shrinking. Our census is showing that we're living longer. And as we live longer, we have different needs. This body, in the last budget, gave an extra $1 million to Adult Protective Services. And I thanked every single one of us for doing that because that is a need. There are just so many of us who respect and regard our seniors, our Manumco, but how do we balance it all? We often say you need to work, you need to be responsible, and what I think this legislation is going to do is going to help those workers, those family members, continue to be responsible as they take care of their growing children and as they take care of their parents. So while I've always said that the employment opportunities are not responsible for everything that you're doing, I think in this regard, this is important. Because if we don't do this, then what happens is people need to stop working. Because the dilemma is, how else am I going to take care of my grandparents or my parents? And if I don't, who's going to? It is a real dilemma, Madam Speaker. It just is. And it's a community issue that we need to talk more and more about. And of course, it starts with early childhood education. It just always does. But this particular case will help those of us who are caring for both and for ourselves. Taking care of our growing children, we're taking care of our older parents, and we're taking care of ourselves. And by the time it's all done, there is no more energy left. But how to do it in a responsible, caring, loving manner. And as you said, Madam Speaker, that's one of the traits of our people. We care. And this will help those of us continue to care and to make all of those ends meet as we juggle all of the balls. So, Madam Speaker, I stand in full support of Bill number 405-32. Thank you.
You're welcome, Senator. Is there anybody else who would like to speak on the motion? Senator Nicholas, you're recognized.
Thank you, Madam Speaker. I'd like to commend the author for introducing this bill. I fully support it. One of the things that we need to factor in, Madam Speaker, is the fact that a lot of our employees make the effort to plan their retirement around the accumulation of their annual leave. And they do this as a means for them to be able to retire based on what their target dates are and what their target annuity is supposed to be. And for us to be having a system where they may have so much sick leave, but they can't use it to take care of their loved ones unless they use their annual leave, we're basically telling them you either give up your retirement aspirations and everything you've been working hard for to take care of your sick family member, or you let your sick family member take care of themselves. And that's just absolutely not something that I'm going to prescribe to. So this simple amendment will allow for employees who still have accumulated annual leave be able to keep that so that they can use instead their sick leave to take care of their family members. Now, how on earth can that be regarded as bad policy? Allowing our people to take care of their sick loved ones. Would we rather have sick children being sent to school because nobody can take care of them and then make the entire class sick? I mean, that's the alternative that we're trying to present to the community. I don't think it's a sound alternative, and I don't think it's sound policy. So this is one of those bills that not only speak to the heart and speak to what we value in this community with respect to family, but they also speak a very great deal to what we should consider as good policy, and that's the public health and well-being of our community and the retirement aspirations of those who are getting up there in years and are looking forward to clocking in and on their last day and calling it a day thereafter. And so, Madam Speaker, I rise in full support of Bill 405. Thank you very much.
You're welcome. Is there anybody else who would like an opportunity to speak? The author, to close, you're recognized.
Sitos Masi, Madam Speaker. Madam Speaker, I'd like to thank my colleagues who supported, rose in support in this bill, but also for the concerns that came up. When this issue came to me, Madam Speaker, it wasn't an easy issue. But you and I know that in the community that we live today, there are some times when we don't have anybody else but ourselves to take care of our loved ones. And, you know, back then, it was easy because even if you weren't related to somebody, if somebody had to go take a child to the clinic or to the hospital to see an ailing parent or an emergency, the neighbors were so willing to say, don't worry, Hanawa, and, you know, Guau Latman, or I'll take care of it. Nowadays, it's just really not the same. And when I received this idea to look at, it said it would be so much easier from a family perspective if I was allotted that opportunity, instead of, because if I don't go to work and get leave without pay, I'm defeating both purposes. I can't take care of my loved one, and then I can't support my family needs. A lot of us here live paycheck to paycheck. But with this benefit allotted to the employee and being able to use it to just take care of it, we already know that there's safeguards in place. And Madam Speaker, as an island community, you know, taking care of our loved ones is very, very important part of our culture, of who we are. I mean, you spoke earlier about taking care of our elders, and not like before, it's not easy sometimes to having to take care of a parent when you know that you have to support a livelihood. And more today, things like this are happening where families are saying, but if I don't go to work, I won't get paid. And I have this benefit that was afforded my way, but I want to use. And one of the retiring speakers spoke about how that benefit is earned toward, that they work hard for, toward a retirement pension. But if that employee wants to give it up to help a loved one, then let us give them that opportunity. Not too long ago, Madam Speaker, that opportunity was given to our employees within the government. It was given. It was only 2 or 3 terms ago when the amendment was put in to exhaust everything else before taking care or utilizing that sick leave benefit for the employee, him or herself. So, Madam Speaker, you quoted that the safeguards are in place and who can utilize this, and if we're going to use it for a family loved one, a family member, that we understood what immediate family meant, and that of course the safeguards on if there was an urgent condition, or if someone had to have an extended time at the hospital, or if someone needed a constant taking care of, that there are provisions already put in place that we would have to follow. And I made sure that that was included in the legislation. So with that being said, I just want to thank my colleagues for sharing their perspective. And before I move to put this down in the voting file, I'd like to ask if I can include Senator Aileen Yamashita and Senator Mike Siniclas. And if you want, Speaker Wampat, I would appreciate adding you on.
On the amendment to include Yamashita, Nicholas, and Wampat as co-sponsors, hearing no objection, so ordered.
Thank you, Madam Speaker, for giving me the opportunity to speak on this bill.
So on the motion then to send 405 to the third reading file without any objections, so ordered. Senator San Nicolas on Bill 383.
Thank you, Madam Speaker. I'd like to make a motion to place 383-32 in the third reading file and be afforded an opportunity to speak on the measure.
And so this is as introduced.
Yes, ma'am, as introduced.
You may proceed.
Thank you, Madam Speaker. Bill 383-32 is an act to adopt the Uniform Electronic Transactions Act by adding a new Division 11 to Title 13 of the Guam Code annotated. Basically, Madam Speaker, what this bill does is it adopts a Uniform Electronic Transaction Act that's been adopted throughout most of the United States that allows for transactions to be closed electronically, electronic signatures, etc. And so we've taken the state models that have been adopted in 47 states, the District of Columbia, Puerto Rico, and the Virgin Islands, and we've adopted it to fit with our Guam Code. And that's basically what this law does, is it allows for these uniform electronic transactions to be conducted legally and to be binding and applicable to the currently existing Guam Code. One of the attractive things about adopting something that has already been adopted in various states and territories is it's already been tested, or it has been tested in certain circumstances under the laws of those respective jurisdictions. So we can safely say that so far, the Uniform Electronic Transaction Act has not resulted in any major legal issues in any of the states or territories that they've been adopted in. So we can with confidence move this item forward, and I'm hoping that I can get the support of the body. Thank you, Madam Speaker.
You're welcome. On the motion for Bill 383, no one? So on the motion then to send 383 to the third reading file, hearing no objections, so ordered. Mr. Vice Speaker, on 419.
Thank you very much, Madam Speaker. I'd like to move the Bill 419-32 COR as amended by the Committee on Appropriation, Public Debt, Legal Affairs, Retirement, Public Parks, Recreation, Historic Preservation, and Land be moved to the third reading file, and ask for a short opportunity to speak.
You may proceed.
Madam Speaker, you and I and several members of this legislature had been approached by members of the community who are currently operating charter schools and are going to be opening charter schools. The charter school legislation gives the authority to the Charter School Commission to approve charters, and a couple of months ago, I guess it was, I can say a couple of months ago, it approved a charter by a group called iLearn Academy. And when they approved the charter, they also approved that it would start on January the 27th of this year. As a consequence of that decision by the Commission, the organizers of that iLearn Academy came to speak to us about trying to get some authorization in the budget bill that was passed, 32-181, to authorize that the $5,500 that we've approved for charter school students, per student, be also afforded to them at iLearn. Initially, they told me $250, but then later I understand after the public hearing that the commission had approved 358 students. So I quickly wrote this bill, and at the public hearing, much to my great surprise and very happy about the fact that actually seated at the table was the chairman of the commission and the chairman of the boards of both iLearn and Guam Academy. And all of them were in agreement. I mean, I still am scratching my head. I was so excited about the fact that they all agreed that the $5,500 would be sufficient for right now. If and when we change that, in the next budget, fine. But right now, $5,500 per student would be acceptable. They presented a budget for their 358 students and the administration of the school. It had been approved by the commission. And the commission also came before us, and though they had initially only approved 520 for Guam Academy, the commission came before the committee that day and asked that we amend Public Law 32-181 to increase the enrollment at Guam Academy from 520 to 600. It seemed that in the interim, Guam Academy had expanded, unbeknownst to many people, and but the school and the operation has been working out well, and they now have 601 students. And so it was agreed at the hearing by the commission and by the heads of the two schools that they would cap their enrollment right now at 600 for Guam Academy and 358 for the iLearn Academy. And I know, Madam Speaker, that you're concerned about the fact that you've received word from GDOE that they've divided up the money. But when we appropriated the lump sum to GDOE, it was for all public school students. And public school students includes these students in the charter schools. And so we have carved out and accorded 600 plus 358 to receive $5,500 per student for the operation for this year, and they will have to figure that out. I mean, I'm not going to try to manage for them, but we did appropriate a sufficient amount of money for them to do their operation. And so this piece of legislation simply amends 31-181 to say that the $5,500 per student would be accorded and afforded to 600 students at Guam Academy and 358 at iLearn, pursuant to the charters they received from the commission, which we enacted. And so I asked my colleagues to approve this piece of legislation. The chairman of the commission was here and asked that the numbers be amended upwards from what I had originally had of 520 and 250 to 600 and 358. So I asked for my colleagues' support in this piece of legislation. Thank you, Madam Speaker.
You're very welcome, Mr. Vice Speaker. Speaker Wampat, you're recognized on the bill, on the main motion.
Thank you very much, Madam Speaker. Madam Speaker, I'm glad, of course, that the the mover, or the author of the bill, had indicated that I had, some discussions as well with the superintendent of education, and he is correct, is that when we appropriated, the monies to DOE, it's a lump sum. And in my discussion with the superintendent, what he had done is that he had sat with all of the deputies and the school principals and the division heads to basically divvy up, the budget so that everyone would know what they're getting, and was concerned then that having done that already, and now with this additional appropriation, and it's not just any more 520, but an additional 80 more students for Guam Academy, and then the other is 358 students for the iLearn Academy. And the concern now was having to go back and see where now they're going to pull monies from the different divisions and different schools to be able then now to provide the funding of $5,500 per enrollee in these two charter schools. So that was, his primary concern. At the very beginning also, when we started to talk about the budget, the chairman, of course, did indicate and was concerned that, we couldn't give as much as we would like to GDOE, because as you know, there are a lot of competing interests from the entire government on funding. And of course, my vice chair, Senator Yamashita of Education, was part of the discussion as well, and was concerned and had an initiative for early childhood to be able to support it and get it going. Fortunately or unfortunately, because they were not quite ready, the amount of money that was supposed to be earmarked specifically for that program, that she was able to work with the committee, both OFB and Education, to be able to then try to put the money's best use of that $5 million that was identified by the governor specifically for that in order to get it going, is that we want to put money in to get the coordinator to start planning and preparing for next school year, which is a good thing. Then the other is, in another discussion, is that money also was put in for the adult protective services. And so the balance then went to DOE in that lump sum. And we all knew going into that it wasn't going to be sufficient to address our schools entirely the way we would like it to be. We never were able to, because all departments, of course, and agencies, would want a lot more. The good thing about the Charter Academy, the way it was written, the bill was designed to make sure that they help our public schools by alleviating some of the overcrowding in our schools. And the second thing was to be able to provide programs, initiatives that are innovative, motivating, new, creative, you name it, providing a different approach to the learning styles, the different learning styles of our children. And that was the whole purpose of it, to make sure that they're not replicating exactly what is happening in all of our schools. And of course, there's a limit in the number of which that could happen. The one thing that I was concerned, though, in my discussion with the group, though, and is that when we say that this is a public school, that means then that the children that should be in that school, these two charter schools, are children from our public schools. Very similar to a program I know that some would love to have, is a voucher system, but that's not what the government is all about. It's to take government monies for our public schools, take it and then and turn it over, take the voucher over to a private school. It's supposed to remain in the public school. And that's what I'm hoping, and that's why I'm speaking on this, because I want to make sure that the children who are in these two academies are children that came from or are coming from our public schools, because those are public monies to make that a public school. It is not to open these schools and leave it completely wide open for anyone in the community to be able to come into these schools. So I want to make sure that that is happening, and that's why I'm speaking to that. The other thing that of course, that I feel that is important for everyone to know and have some sense of assurance that I know in the beginning we had a lot of problem in terms of being real open and transparent about what was going on our very first academy. That a lot of there was a lot of pushback and even the unwillingness to speak openly to the legislature and only through an attorney. And that was, of course, an insult and a slap in the face to the government, not just the senators who are doing this oversight hearing, to say that, we can't ask any questions regarding local dollars and how they're being spent, and following, of course, certain laws, and in particular procurement laws. That was very important. Only to find out, of course, that it uncovered a lot of things that everybody started then to question. What I was trying to say, that the good thing about this is that the iLearn Academy was watching very carefully what was going on and wanted to make sure that they didn't fall into that same path, and that had all of the questions that were being prepared by the committee, and then just through the public hearing was able then to take every single one of those concerns and address it on their own as they start to plan and build on this academy. It's a little bit different, not a little bit, a lot different versus the first one, where there was that question that at one time the department had a DI, and now this school academy is doing exactly what the department has just decided to no longer pursue and went on to Common Core. This other iLearn Academy now is going to be using technology, e-books, and so that's definitely very different from what our schools have been using. Although our public schools have started to use technology a lot more than they were able to, and that's because of funding that was made available, our monies that were made available to provide all of these computers in our schools, in classrooms, so our children will have access to them, and also computers to be made available for our educators, our teachers, who will be using that same technology as they are teaching our school children. So in that sense, it is different from the traditional teaching in our school system. I know that we're going to, depending, of course, on how this is going to affect the budget of DOE. Fortunately, I know because we are early on in the first quarter, and hopefully, I know with one piece of legislation that we sent down to the third reading file, that although we had budgeted everything, we're hoping that there will be some additional monies that will come in, that should the department then find itself down that road where they really are very short, that then we could address this somewhere in the second quarter or third quarter, whatever the case may be. I'm not saying I'm making any promises, but I know that the government has been very responsive to make sure that we address, the needs of the three most important agencies, which will be for health, education, and public safety. So I know that this legislature has always stood firm and ready to be able to assist, our government. So I know that everyone's probably expecting me to really stand up here and take the position that I'm, totally against this. I'm not against this. I just think that, and that's something we're going to work on, because the commission already has indicated to us that they do have several amendments that they would like to recommend to the legislature then, because we gave them that opportunity and they had some time, and the only once have they come to this body to make a change. The other second change we made, we did it on our own, and that was the procurement law. So hopefully the third would address some of these, and I know, and this was discussed with the commission as well, is that they have been working on this with this one particular academy, and it's unusual, of course, that we open a school midstream when things are moving on, and that maybe we need to look at the legislation to tighten that up, to make sure then that we do justice for not just our public schools, the main public school, which is the Guam DOE, but our other public schools in the form of our academies, that then we can make them whole with the appropriation, and hopefully at the beginning of a school year instead. So, Madam Speaker, I thank you very much for the opportunity to be able to provide, some additional information on the on this bill and the Charter Academy and the Commission itself. Thank you very much.
Sizus Masi, Madam Speaker, are there anyone else wishing to speak on the main motion? If not, anybody else? If not, Vice Speaker Cruz, you may close on your bill 419.
Thank you very much, Madam Speaker. No, it's sort of strange when you take over a chairmanship from somebody else, you all of a sudden end up having to be champion of certain things that you may not have been champion of in the past. And I suppose it's poetic justice that I get stuck with it. But I just wanted to make a few things, put a few things on the record, Madam Speaker. I really do think that we have to acknowledge and we have to recognize that the Guam Department of Education and the public school system is for every child on this island. This belief that the children going into the charter schools must have come out of the public schools has to be dispelled. That cannot be the basis of which you have the charter school enrollment. Just this morning, I received an email from a woman who was seeking financial assistance. She's pregnant, and because she has a problematic pregnancy requiring specialized care, it's resulted in her inability to be able to continue to work. And so she's had to resign her position, or actually she's been dismissed from her position by her employer. Unfortunately, she's not working for the government and protected by the classified service. She's been dismissed. She also puts in her email that her husband last week was also terminated from his employment, and they're in need of assistance. When both of them were employed, they probably could have afforded to go to one of the private schools on the island. But now that both of them are unemployed, they're going to have to be taken, their children are going to have to be taken out of the private schools and into the public school. I really am hesitant to think that we're going to say that child cannot and should not, or those children cannot or should not be considered as eligible to go to the charter schools because they weren't in the public school system to begin with. All children on this island are our responsibility and are eligible to be public school students. There are changes in family circumstances, whether it's death of a family member, employment of a parent, that will cause children to have to go from private school to public school. And if the decision is, and they're lucky enough to be in the lottery, to be selected to go to one of the 2 charter schools, then we cannot discriminate against them and say they cannot be included as part of that list because they weren't part of the list that started out in September. Elections come and go. Some of our members are unfortunately going to be leaving. Fortunately, none of them that have children or that young that are in school or would have that the loss of this job is going to cause them to move their children from private school to public school. But if that was, they would have to be part of the public school system and cannot be said to not be part of the number of the 358 or the 600. So I really it's strange for me to have to defend this, but we have to be very careful about the way that we state that, because all 45,000 children that are in the school system, not just the 31,000 that are currently in the Department of Education, are and should be considered eligible for these charter schools. And so I just wanted to make that clarification. And the amount of money that we're talking about for these 2 is minimal. The 80 students that we're adding on to the Guam Academy times 5,500 comes out to 440,000. Since it's only a half a year that we're going to be providing for this when this becomes law, that's 220,000. The 5,500 per student for the 358 students that we're going to be providing for at iLearn, if it was a full year, it would be 1,996,000. For a half year, 984,500. The total for these 2 schools for the next 6 months is $1.2 million. This claim by GDOE that they can't afford the $1.2 million is specious. My initial support for this legislation was half-hearted. It was as chairman of the committee that I had to take it up. But when there's question as to where $1.2 million is going to be found for 400 students, though I have no students in school, I have no children, I have to stand up and for them. You all know that I was not one of the original proponents of charter schools. But if it was the policy decision of this body to create this, then we must fund it. And so I ask my colleagues, please, the commission that we created gave the charter to start on January the 27th. They're trying to do it. The commission that we created increased the charter from 520 to 600. We have to fund it. So let's move and pass Bill 423. Thank you very much.
On the motion to send 419 to third reading file, No objections? So ordered. Senator Rodriguez on 422-32.
Thank you, Madam Speaker. Madam Speaker, I move to place Bill 422-32 as substituted by the committee on third reading. Be allowed to briefly explain what it is.
You may proceed, Senator.
Thank you, Madam Speaker. Madam Speaker, a few years ago, this body enacted the isolation and quarantine regulations that would provide the necessary tools to our first responders to protect our community and our people from any threat of communicable disease. What this bill does now, Madam Speaker, is expands these tools that we're giving to our first responders by taking into consideration the different types of diseases we're seeing now worldwide. This also takes into consideration the time frame that is necessary to be able to test and confirm the presence of any of these diseases on any individual, as well as the incubation period that these diseases are present in our system. The bill also, Madam Speaker, what it seeks to do is authorize the Governor of Guam to be able to procure the necessary personal protective equipment, also known as PPEs, to ensure that our first responders, people who are tasked to care and to respond to any of these are protected. The $130,000 amount that was identified in the bill was derived from consultations with Homeland Security and public health officials. So, you know, it provides for this initial procurement of PPEs, but then it also directs that these agencies include it in their budget requests moving forward to ensure that they are properly equipped with the necessary PPEs that may be needed in the future. Madam Speaker, this bill, what it really does is a proactive approach to the protection of our community against any threat of communicable disease. It's being done now, as we've done during the last term when we established the isolation and quarantine regulations. I think doing this puts us ahead of the curve rather than reacting and doing these things in a panic approach manner. And so I ask my colleagues to please give favorable consideration to this measure. It's been worked on together with our first responders, Homeland Security, Public Health, Customs, the airport, the hospital, all the necessary stakeholders were part of this measure. And so I again ask our colleagues for their support. Thank you very much, Madam Speaker.
You're welcome. On the motion on Bill 422. No one would like to speak on 422 on the motion. So on the motion then to send 422-32 to the third reading file without any objections, so ordered. For 24, Senator Respicio, you're recognized.
Thank you very much, Madam Speaker. Madam Speaker, I move to place Bill 424 in the third reading file with some discussion first.
You may proceed, Senator.
Thank you, Madam Speaker. Madam Speaker and colleagues, Bill 424 simply seeks to clarify the existing rules and regulations with respect to the commercial quarantine facility. You know, I want to start my comments by saying that this issue has been lingering for the last 6 years or so, but more specifically, over the last 6 months, my committee, together with Senator Yamashita, who's also on our committee, attended a series of status hearings between the Department of Agriculture and the territorial veterinarian and a few other veterinarians here on the island. And you know, Madam Speaker, I think the biggest thing that we've accomplished so far is to require the territorial vet and the Director of Agriculture to inspect all the existing animal quarantine facilities and to move forward on a permit request by another proposed animal quarantine facility, not to tell them that they have to pass per se, but to tell the Department of Agriculture and the territorial vet that they have a fiduciary responsibility to follow through on these permit applications. And so what we've learned is that for the last 6 years, the territorial vet and the director of agriculture refused to inspect the proposed animal quarantine facility because they simply said, we drove by and the perimeter fence is wire. It's concrete, it's not wire, and the current rules and regs require that it be wire fencing. And so after back and forth and much efforts that were made through the status hearings, the director and the territorial vet finally inspected the proposed animal quarantine facility. However, they used a different standard from what they used to inspect the other facilities. And so, colleagues, Madam Speaker, I really don't want to get into that right now because many of us have received a lot of emails back and forth on both sides of the issue. I think the most perplexing thing at the public hearing for this bill was when both the Director of Agriculture and the territorial vet testified that my bill to accept concrete walls or wire fencing or want to add in metal is really dumbing down or weakening the quarantine laws here on the island. Now I submit to you just one basic question. What's more secure, concrete or a wire mesh for a facility barrier? And these fences or walls, Madam Speaker, is really designed to prevent the escape of dogs or cats in quarantine, to prevent the entry of non-quarantine animals or unauthorized personnel. If you look at the proposed animal quarantine facility in question, you almost have to get through 3 solid barriers before reaching the dog or cat, and vice versa. The dog or cat would have to exit or escape from 3 solid barriers prior to leaving the facility. And this bill is not designed for one facility over the others. If that were the case, I would have just introduced a bill that said you must simply have concrete wall or concrete fencing. So this bill basically says unless a solid roof covers the entire facility, the premises of a CQF or a commercial quarantine facility shall be surrounded by a perimeter fence no less than 8 feet in height and topped with barbed wire tilted inward. Fencing shall be composed of concrete, solid metal, or wire, and all wire shall be of a mesh size of 2 inches by 2 inches or less, and no less than 9 gauge. And so I certainly, whatever happens with this bill and whatever the governor's disposition on it, if he even is able to get it, I certainly will continue having these status hearings to make sure that we level the playing field with respect to all laws before the territory, but more specifically this whole issue of all the veterinarians with the territorial vet, with the director of agriculture, and all others involved in monitoring this issue closely to make sure that all individuals have been treated fairly and that there's parity. And so I ask support for this bill, and if you want to engage in a conversation regarding this bill, certainly we need to do that. But the main question I submit to you and our colleagues is, does this bill weaken the requirements of an animal quarantine facility when it recognizes concrete or cement in addition to metal or wire? And so this is my presentation on this bill, and it's not something I'm trying to rush at the 11th hour. As I said, it's been an issue that's been ongoing for the last 6 years or so, but specifically over the last 6 months, my committee's been actively involved in trying to resolve this issue by separating all of the personalities and just trying to focus on what is the good public policy with respect to this issue. Thank you, Madam Speaker.
You're welcome, Senator. On the motion, on Bill 424, there being none, then to send 424 to the 32 to the third reading file. So ordered. 427, Mr. Vice Speaker, you recognize.
Thank you very much, Madam Speaker. Madam Speaker, I asked to move Bill 427-32 COR as substituted by the Committee on General Governmental Operations and Cultural Affairs to the third reading, and I'd ask for a short opportunity to speak.
You may proceed.
Thank you very much, Madam Speaker. Madam Speaker, when I initially introduced this piece of legislation, it was going to be very simple. It was brought to my attention that the enabling legislation for the Council of Arts and Humanities had a provision that you can see on line 12 of the bill. It says, no person shall serve more than one 4-year appointment without interruption. It was brought to my attention as chairman of oversight for culture that there was this provision in the initial enabling legislation to create CAHA, and that it was going to create a problem in that certain members who are currently on the board will not be able to be reappointed to the board. And the concern that was expressed to me was that the members of the CAHA board that are currently on the board, as you know, Madam Speaker, being on the oversight, the FESPAC commission, each member of the CAHA board has been assigned as the point person with each one of us who has a committee. And if this provision of law remains in effect, then some of these board members will not be able to get reappointed, and as a result, the continuity in the preparation for the FESPAC of 2016 will be interrupted. And it's imperative that the historical knowledge that these board members who have been assigned to each one of our various committees, and who actually, some who serve actually on our overarching commission, be allowed to continue so that the work and preparation for FESPAC continue uninterrupted. And I don't mind saying it, and I publicly will applaud the fact that probably the most active member on the commission has been the chairman of CAHA, Monica Guzman. And without a repeal of this section, she would not be able to be reappointed next month and would therefore not be able to continue to serve on the commission in the capacity that she is currently. And so initially that was the reason for my introduction of the legislation, was to just remove that one prohibition of the uninterrupted terms. When I conducted the public hearing, much to my surprise, but actually I was very elated to hear it, Mayor Gogui came from the Mayor's Council and asked, by resolution of the Mayor's Council, to actually be placed on the CAHA board. And I thought that was great, because I know that the mayors are very busy, and sometimes they object to us giving them additional responsibilities. But in this case, they actually claimed to us and petitioned by a letter from their board, from the council, asking to be placed on the commission, on the CAHA board. And I saw no reason why we could not or should not include them. As you may know, Madam Speaker, though Pa'atatautana was the initial group that started a lot of the cultural renaissance, it's been mayors like both mayors of Zonia, who have been very supportive. The mayors of Agate have supported the use of their village centers for Simidza. Zonia has been used as a center for Rasan Atolati. The mayor of Dededo. The mayors have been very, very active in the cultural renaissance on this island. And when they came to the committee hearing and asked to be put on, I thought it would be a disservice to them and to the community to not include them. And so that's why the bill is substituted to include a provision that the governor be able to appoint a member from the Mayor's Council to sit on the CAHA board, and it was by their request to have that done. And so this substitute bill does two things. One, it removes the prohibition against successive terms of members of the board, and two, it adds a member of the Mayor's Council to the board. I know that some of you are going to be concerned about the fact that there's now an even number on the board. I think we can deal with that. The problem is trying to get quorums to the board meetings, and if they can get a quorum, they should be able to vote and be able to handle whatever needs to be done. But we need to continue the work for FESPAC with the board members that are there, and if the mayors are willing to step up and want to assist, as they have done in the past with starting and supporting the cultural groups within their villages or whatever others. I mean, we have mayors that are very talented. I know one mayor that I think he has a CD out. Another mayor is a pianist. And another mayor heads the choir within his village and is also an accomplished musician in his own right. So there's lots of talent within the Mayor's Council, and they want to be on CAHA. And I think if they're willing to do it, and they were the ones that asked for it, I think we should allow them to come on the board, and we should allow for the board members to have successive terms by removing this prohibition against uninterrupted terms. So with that, Madam Speaker, I thank you very much for allowing me to speak on Bill 427, and I ask my colleagues for their support of Bill 427.
On the motion, Senator Yamashita, you're recognized.
Thank you very much, Madam Speaker. I stand in support of Bill number 427-32. I absolutely agree that experience, longevity really adds to quality of work, and it does make a difference. So I appreciate that amendment. And I do ask about the number. On boards, even numbers, not always, but sometimes can lend to problematic decisions. And I'm wondering, and I'm just proffering this, I'm not actually making an amendment, I'm just raising it as a thought. If it was changed to 13 members and that there would be 2 members to represent, because right now on line 19, the governing board shall have at least 1 member representing those particular areas, performing arts, visual arts, literature, and folk arts. And if it went up to 13, then the governing board should have at least 2 members to represent what the council represents. And again, I'm not making an amendment, I'm just asking for discussion by the author of this. Would that hinder or would that help the issue of the even number of board members?
Mr. Vice Speaker, do you yield to the question?
I have no objection, actually. I think maybe if we just increase the governor's appointments and have the governor be able to appoint 6 members to serve 2 years and 6 members to serve 4 years. And the mayor would make the 13th. And then that way we don't have to worry about it. So I make the amendment that on line 8, we change that to 5 to 6.
On line 8, shall designate 6 members, and then where it says 5 to increase that to 6.
And to address the concern of the retiring speaker, would on line 20 to change 1 to 2.
And then 20 it would be 2. And then, of course, we're going to go change it from 12 now to 13 members on lines 3 and 4. All that. Is that correct?
Correct.
And then,
Actually, there'd be 3 amendments.
yeah, well, there's...
On line 4, 11 to 12.
Yes.
On line 8, 5 to 6. And on line 20, 1 to 2.
Okay. On the amendment, no objections? So ordered. Senator Yamashita, you still have the floor? You're okay? So on the motion then to send 427 to the third reading file, no objections? So ordered. Mr. Vice Speaker, can you come up here and cover one?
Madam Speaker, you're recognized.
Thank you very much, Mr. Speaker. Mr. Speaker, I'd like to make a motion to place Bill 430-32 to third reading file. And what it is that the title, of course, is to appropriate the balance of $53,006 from the funds not obligated from Public Law 32-65 to purchase mobile radios for police vehicles.
Hearing no objection.
Thank you again very much, Mr. Speaker. Mr. Speaker, we had passed Public Law 3265, and what that did was that it authorized, of course, the Guam Police Department to purchase 7 vehicles, and they have, my understanding is that 2 already have arrived already, and the others should be here. The remaining should be here, but there is, however, a balance from that total amount of $53,000. And the Chief of Police, of course, had actually requested that since they have that amount of money, they would really like to be able to use it to purchase now what they call mobile radios for these police vehicles. And so it's very simple. And by the way, I did work with Ricky and your staff to make sure that the language that we use in the title when we say an act to appropriate, because I know there was a concern whether we should actually put the dollar amount. So I ran that through OFB to make sure that the language that we're using here actually is sufficient. So it's very simple. It's just the balance. Already this money has been appropriated. They have used it with the exception of the balance of $53,000.
Any senator wish to be heard on the bill? I mean, on the motion, on the main motion, the bill. Madam Speaker, and any senator wish to be heard on the bill? On the motion to send it down to voting file, hearing no objection, so ordered. Let's break for lunch and at 2 o'clock. All right, we'll start with Senator Rodriguez, and then we'll finish up with the Senator Nicholas and Senator Limtiaco bills. Okay?